A guy made a bet with his teenage nephew at a family party in 1869. The deal was simple. Stop drinking, stop smoking, stop gambling until you turn 21, and I'll hand you $5,000 on your birthday. The nephew said yes. He did it. And then the uncle's estate refused to pay. That fight over one family promise is now in basically every first-year contracts casebook in America. Buckle up, this one's going to change how you think. The case is Hamer versus Sidway. It's 1869, a golden wedding anniversary party in New York. William Story Sr., the uncle, pulls aside his nephew Willie, who's 15 or 16 at the time, and lays out the deal. Refrain from drinking liquor, smoking, playing cards for money, or playing billiards until your 21st birthday, and I'll give you $5,000 that day. Willie agreed, and the uncle even built in a carve-out. Playing cards for fun, not money, was fine. Willie held up his end for years. When Willie turned 21, he wrote his uncle a letter. He called it their agreement and said $5,000 was due to him. The uncle wrote back, acknowledged the money was sitting in the bank, and said Willie had earned it by picking up good habits, but then said he wasn't handing it over yet because Willie might squander it. He told Willie to consider this money on interest. Willie didn't push back. He went into business with his father and they borrowed $2,500 from the uncle. Eventually, they went bankrupt. And in the bankruptcy filings, Willie listed 0 claims against his uncle. 0. He also signed a general release after a later transaction involving goods worth $11,000. The uncle died without ever paying. And then a guy named Hamer, who claimed to have acquired the right to collect through an assignment from Willie's wife, sued the uncle's estate. The executor, Sidway, defended on 3 grounds: no valid contract, no valid trust, and even if there was a contract, it was barred by the statute of limitations and released anyway. The trial court found for Hamer, but then the Intermediate Appellate Court, the New York Supreme Court, which in 1890 wasn't the state's highest court, reversed. This is where 90% of people fail. There are 2 versions of this case floating around, the lower court reversal and the famous Court of Appeals opinion where Hamer wins. Professors sometimes assign both because the procedural history matters. The doctrinal spine is the same in both. What separates a binding contract from an unenforceable promise to make a gift, and how does the legal detriment theory of consideration do that work? I've thought about this case in terms of the deals I've made in my own business. When we first started booking meetings for clients at scale, we've now booked over 500,000 meetings total across our companies. A lot of the early agreements were handshake deals or quick emails, and consideration and legal detriment weren't part of the conversation. But when money doesn't move after someone performs, questions come up about whether the deal was enforceable, and that's the exact question in Hamer versus Sidway. I've done this at scale, not just in theory. When does a promise to refrain from doing something count as valid consideration for a contract? Specifically, can giving up activities that are legal but only harmful to yourself, drinking, smoking, gambling, count as legal detriment? On an exam, that fact pattern triggers 2 questions at once. First, the consideration question. Was Willie's forbearance a legal detriment, a benefit to the uncle, or neither? And second, the gift question. Does the surrounding evidence, the word give, the uncle's framing, the family talk about a nest egg, recharacterize the whole thing as an unenforceable promised gift? So let me break this down for you. A valid contract requires consideration, which means either a legal benefit to the promisor or a legal detriment to the promisee. A legal detriment means giving up something you had a legal right to do. Regardless of whether that forbearance is economically harmful to you, Willie had a legal right to drink and smoke, and he gave that up. Under the Court of Appeals version of the rule, that's enough. But the lower court used a stricter test. It wanted consideration to have pecuniary value, meaning some financial benefit to one party or financial burden to the other. There's also a sub-rule. Moral obligation alone isn't consideration. A gift is unenforceable without delivery, no matter how clearly the donor expressed the intent. And an incomplete gift can't be relabeled as a contract after the fact to make it enforceable. These 4 points together are what separates a binding deal from a generous promise. That right there is the whole game. The lower court's reasoning goes like this. The uncle used the word give, which ordinarily signals a gratuitous transfer, not a bargain. A witness named Maggie Judson, a family friend and domestic worker, testified that she'd heard the uncle talk about this money for years, but she never heard him call it a contract. She described it as something he intended for Willie, a gift to motivate him, a nest egg if he turned out steady. The court leaned heavily on that testimony to classify it as a gift rather than a bargain for exchange. The court also ran the consideration analysis as a backup. Even if this were a contract, it said, where's the pecuniary detriment? Willie gave up habits that were unnecessary and evil, and refraining from those things didn't add to his financial burden. It arguably saved him money. The court distinguished an older English case called Shadwell versus Shadwell, where a nephew's marriage was found to create additional financial liabilities. But Willie's abstention from vices didn't create any comparable monetary burden. Then the court knocked down the trust theory. The plaintiff argued that the uncle's letter, where he said consider this money on interest, created a trust, making the uncle a trustee of the $5,000 for Willie's benefit. The court rejected that completely because there was no explicit trust declaration, no evidence the uncle ever put money in the bank in Willie's name or labeled it as held for Willie. The court cited a standard from Beaver versus Beaver. A trust requires either explicit declaration or circumstances showing beyond reasonable doubt that a trust was intended, and consider this money on interest just doesn't get you there. And then there's the credibility problem. Willie didn't mention this claim in his bankruptcy filings, even though he was sworn to list all debts owed to him, and he signed a broad release after the $11,000 transaction. The original complaint said Hamer got the claim by direct assignment from Willie in 1887, not from Willie's wife, and the wife's prior assignment only surfaced as a response to the release defense. The court found the evidentiary picture unreliable across the board. I'm going to make this really simple for you. Courts are skeptical when someone sues a dead person's estate over an alleged promise the decedent made years earlier because the person who could explain what they meant is gone, and the only people left talking are the ones who want money. The court in Hamer explicitly flagged that estates get assaulted by dissatisfied relatives and said claims against dead people's estates deserve extra scrutiny. Now let's run a quick hypo. Aunt Rosa tells her 17-year-old niece Camille that if Camille stops eating junk food, keeps her GPA above 3.5, and doesn't get a tattoo until college graduation, Rosa will pay off Camille's student loans, roughly $40,000, on graduation day. Camille does all three and graduates with honors, but Rosa says she's proud and never pays. Rosa dies 6 months later, and Camille sues the estate. 3 issues. First, gift versus contract. Rosa named a specific amount and a specific trigger, graduation, which looks like an offer with acceptance and performance. Arguments the other way. Rosa said she'd help Camille when the time is right, which sounds exactly like the uncle saying he'd hold the money until Willie proved he could manage it. If witnesses testify Rosa always framed this as family help and not a deal, that evidence pulls toward gift under the Hamer lower court's approach. Second issue, consideration. Did Camille suffer a legal detriment? Avoiding junk food and keeping a high GPA arguably benefit Camille. Better health, better academic outcomes. Under the lower court's pecuniary detriment framing, that's a tough sell. But the tattoo restriction is different. Camille had a legal right to get a tattoo as an adult, and she gave that up. Under the Court of Appeals version of the rule, the famous version, all 3 restrictions probably count because Camille had a legal right to do all of them. So which version of Hamer you apply determines the outcome. Third issue, Camille's silence when Rosa delayed. This mirrors Willie not pushing back on the uncle's letter, and the court in Hamer treated Willie's silence as inconsistent with believing he had a contractual right. If Camille accepted Rosa's "I'll pay you when the time is right" without objecting, that's evidence both sides understood this as a gift. Preserving family peace is a reason to stay quiet, but staying quiet still looks like abandoning a legal right. So the exam fight is whether Camille's silence extinguished her contractual claim. This is the part that ties it all together. The reason Hamer versus Sidway stays in every casebook after more than 130 years is that it draws a line that courts still use. Forbearing from a legal right counts as consideration because the promisee gave something up, and courts call this legal detriment. Surrounding evidence about intent can short-circuit the consideration analysis because if the court decides it was a gift from the start, you never even get to ask whether consideration existed. If you ever need to find someone or run a background check, go to Scraper City. If you want to grow your law firm using outbound techniques where legally allowed, check out Galadon Gold. And to automatically grow on Twitter and X, use TweetLoft. The next video is coming up now.